Hello friends, Namaskaram. How are you? Myself is Dr. Jinesh Soni. I am an advocate and a defense counsel. In today's class, we will discuss an important topic which is concerned with maintenance. I will discuss the recent judgment of Honorable Rajasthan High Court, which is dated 20 January 2026. Whenever a case for maintenance is submitted, like the present case, the wife usually submits a sad story that I have been married with the concerned person. In the marriage, valuable articles had been given. My husband and the in laws used to harass me for dowry, and when demand is not fulfilled, they shunted me outside the matrimonial house. With the help of government, the concerned advocate of the wife used to convey to the Honorable Court the two important principles. Number one, she is residing at her parental house, but not as per her will, but under the compelling circumstances. And apart from that, she is not having any means to maintain herself. The husband is having the means, but the husband is neglecting his duties, and that's why there is a need to intervene. Am I right? So, everything depends upon you in which manner you are going to contest the case. If your method is orthodox, in that scenario, you could not be succeeded. We have to change our patterns, and we have to emphasize on those facts, on those documents which could inter alia germinate the inconsistencies in the statement of I. To understand the said perspective, we will take the following instances. In the present case, the husband submitted that the claim of maintenance is totally fictitious. It is totally fake or false. Because the wife submitted that dowry articles had been given in the marriage, but she had mentioned at a document that no dowry had been given in the marriage. The document is duly signed by her. So, if there is two versions regarding the same cause of action, in that scenario, the inconsistency would definitely affect the claim of the prosecutrix, means the concerned wife. The husband inter alia succeeded on that ground also. Point number two, in the petition, wife usually submits that although I am professionally qualified, but still I am unemployed, I depend upon my father. To counter the said allegation, the husband submitted that she is not unemployed. Previously, she was doing the job, but she left the job as per the legal advice so that she could recover the amount of maintenance on the higher side, and apart from that, she could mount a pressure upon me. So basically, she is going to abuse the process. She is going to create the unwarranted claim of maintenance upon my shoulders, which is not the intent of law. And apart from that, she never depends upon her father. She is having the sources of income, and deliberately she has concealed the same. So, whenever we are going to plead the specific facts, we have to support our reply with the specific evidences. Mere averments are not sufficient to draw inference against the wife. If you are saying that she was previously earning, you must support your claim with the help of supporting evidences. And apart from that, if she says that she depends upon her father, but the income of her father is on the lower side and her expenditure is on the higher side, so it is next to impossible to bear the expenditure of concerned wife by her father. So in that scenario, we could have the benefit. Each and every time we have to draw the inconsistency in her claim, in her statement, so that we could have the benefit. In the present case at hand, the wife submits that the earning of my husband is rupees 1.5 lakhs. By the virtue of law, I deserve 25%. So in that scenario, I deserve approximately rupees 38,000. But trial court has awarded rupees 8,000 only, which is unjustified. The order is perverse, liable to be set aside. While arguing the case, the husband submitted that I had inter alia made payment to the concerned wife towards maintenance on voluntary basis. That is very important perspective. Basically, whenever we spend money on our wife to maintain her, because maintenance simply means the food, clothes, and shelter. So, whenever you spend money towards clothes, shelter, and food of wife, in that scenario, if you are having the record, you could easily submit the same with the help of cash flow statement, and you could easily convey to the honorable court that voluntarily the amount was given, and she has been concealed this fact. So, if the amount is voluntarily given by you and you are having the evidences, you could have the benefit as observed by Honorable Rajasthan High Court. For example, the court awards rupees 10,000 in your case as maintenance to your wife. I know that the amount will not be paid by you. In that scenario, you are going to create the arrears, and ultimately the panic will be caused to you. To avoid the same, can we do one thing? Simply do a FDR in name of your mother or father or sister or brother. With the help of interest to be earned on the said FDR, we could easily encounter the amount. At instance, we are having the bracket of rupees 10,000, and against FD we are having the interest of rupees 5,000. So 5,000 could be adjusted towards 10,000 by the way of set off. So new amount is rupees 5,000, and we could easily pay the same in fractions, means in segments, rupees 100, 50, 40, 30. So we have to play with the scenarios. So nothing is impossible. Even impossible says I am possible. So everything depends upon you in which manner you are going to proceed. In that case, the court observed that the maintenance is neither a punishment nor a measurement of unjust enrichment. It is basically a social measure. The maintenance never mean to claim the equal share in the property or income of husband. The basic object of maintenance is to provide the reasonable financial support to the concerned wife. So the court observed the four important parameters while considering the claim of maintenance of the concerned wife. Number one, the duration of marriage. Number two, the educational qualification of the wife. Number three, the previous income of the concerned wife, the income of the husband along with the liabilities. The liability of EMI is also vital to our case. And apart from that, if she is professionally qualified and was working previously, and right now she has left the job and sitting ideal at home and demanding more maintenance from the husband, in that scenario, we could have the benefit. So simply we have to expose the ill intent of the wife. So if the evidences are inconsistent, your claim is unspecific, you're going to submit a simple reply, then you could not be succeeded. So I think that I have specified you the way to encounter the false case of maintenance. So whenever you are going to draft the reply, just keep in your mind the fundamentals so that you could submit your claim on dominant side. See you in the next lecture. Till then, Jai Hind, Jai Bharat.